Yeah, maybe to play devil's advocate for a second, maybe the difference between taking a knee
Mhm.
and burning a flag. But taking a knee, you don't, maybe the person stands in opposition to the country, but there are other good explanations perhaps you can give for why somebody might take a knee,
Mhm.
racial injustice or et cetera, et cetera. Uh, when you burn a flag, some people would say, well, that's treason
Mhm.
because that's the symbol of freedom and a symbol of this country and liberation. And if you don't like it so much, well, get out. Um, is there is it the same? Are those two things, taking a knee and burning a flag, the same, or is there a major distinction when it comes to free speech?
I don't care if, first of all, it's not treason. There is a specific definition in the Constitution for treason. It requires an actual act of aiding the enemy and so forth. So I think what you're using that term loosely, which I defend your right to do that, as anything that is arguably unpatriotic or showing disrespect for the United States, right? And that's exactly how people see burning the American flag. And even if your message is I hate the United States and I think that we need to have another revolution or a completely new form of government, that is constitutionally protected speech. And this has been in the news quite a bit lately since January 6th, because most people have been following that controversy and whether the speech that allegedly instigated insurrection was or was not constitutionally protected. Know that the standard to punish speech, even speech that is advocating the overthrow of the United States government, is constitutionally protected. So we're not talking only about the ACLU's position here. We're talking about the Supreme Court unanimously, way back in 1969, it was an ACLU case, I'm very proud, said that even advocacy of lawless or violent conduct is constitutionally protected. What is not protected is intentional incitement of imminent violence or lawlessness, where the violence or lawlessness is likely to happen imminently. In other words, the speech poses an emergency. There's no other way to prevent great harm, violence, or lawlessness other than suppressing the speech. So censorship is only a last resort. And as the Supreme Court held in its two flag burning cases, burning the American flag, no matter how offensive it is to people, no matter even if the person is burning the flag precisely to advocate the overthrow of the US government, that's still constitutionally protected. And I think that's correct, Stanley. It may seem counterintuitive, but when you think of the alternative of giving the government more discretionary power to punish speech when there's a more indirect, speculative connection between the speech and potential harm, that's too dangerous because that gives the government discretion to punish ideas that it dislikes, to punish speakers that it disfavors, to suppress organizations or groups or movements that are politically unpopular or powerless. So before 1969, we had a standard in this country, which many other countries still enforce, called the bad tendency or harmful tendency standard, when speech might at some point in the future indirectly cause certain harm, then the speech could be punished. Well, under that standard, essentially all speech could be punished. As Oliver Wendell Holmes famously said, uh, every idea is an incitement. And by that, he didn't mean that therefore we should punish all ideas, but exactly the opposite. If the fact that speech might incite some violent or negative action was enough to censor it, then we'd have no free speech left at all.